The law says that people who are below the age of 18 do not have the legal capacity to take their own decisions and be a part of the contract. If the person is proven to be unstable in mind because of whatever reasons medically, that means he is considered to be unfit to sign the contract. So you will not be able to take the contract forward. Good morning and welcome to the first session in Unit 2 Commercial Law, where we are going to talk about contractual capacity. Now, what is a contractual capacity? We know about contract. We know that definitely contract is an agreement between two persons or parties who are trying to come up on something which is enforceable under law. But who has the capacity to form the contract? So, what does competency and capacity mean in signing a contract? This is very important for all of us to know. So contractual capacity when forming a contract is often referred to either competency or capacity, which means you are having the capacity, you are eligible to enter into a legal contract, a legal binding altogether. Now, before we start discussing about it, let me first try to go through a simple example here. Whenever you are going to apply for a credit card or for a loan or for any other financial instruments altogether, there will be a small checkbox saying that I am above 18 years, and then they say that yes, you fully agree on to the terms and contract, which means for any of the contract, are you in a position to sign the contract? Are you first of all eligible to be a part of that system? So that is why we talk about this capacity or the contractual capacity in terms of signing up. Now, when it comes to entering a legal binding contract, certain people may be considered to take the capacity and certain others might not be in a position. So in short, we say that these people are having the contractual capacity to do so, and certain other people might not be a part of the system at all. So if you are not of 18 years, then you will not be a part of the contract altogether. Now, moving further, let's first try to understand the contractual capacity meaning. Means that the parties are able to understand that a contract is being formed. So first, let's try to understand till here. Formed, that means both the parties are trying to make sense, saying that yes, we are going to get into an agreement. That agreement is enforceable under the court of law. So that means this is very much understandable to both the parties that there is something serious. So when you are forming an agreement, you are understanding the terms and conditions, and then only you can sign on it. If you are not, then this will not be considered at all. Further, the parties must also be able to understand the basic nature. Now, most of us, when we talk to our friends, to our relatives, or to any of the general meetings, we tend to talk about so many things, and that cannot be considered a contract. Now, for example, if I have agreed to help my friend, or I have agreed to help one of my relatives, saying that I will be able to give you some money, or you will be able to get some money. Now, all those kind of things are something called as just an help in terms of relationship, a promise altogether. But then this cannot be formed as a virtual capacity, as a capacity in terms of the contract altogether. Why? Because there's no formal agreement between us. It is only a thing in terms of talking to the other people and getting their approval done. It's just like a help that is offered at the time. But here, when we talk about the contract, it is pretty much serious. It is pretty much important. Why? Because you need to understand the basic nature of the contract. You cannot just go ahead and say that this contract, what I signed, was just for a time pass. This contract, I signed it because I did not eventually know about it. That cannot be considered at all. Contract by nature itself is a serious thing. It is official. So when you sign the contract, you better know the terms and conditions. Secondly, when a party does not understand the nature of contract, the consequences of an agreement that they have entered, the law treats that party lacking at the capacity to form a legal binding contract. Very important that we need to understand at this juncture altogether. I signed a contract without even reading the document. Now, what we typically tend to do whenever we install a software or an application, we are in a hurry that that app or that particular software gets installed faster onto our mobile phone or to our system. So what we quickly do is that we just keep on clicking on that particular word called I agree, yes, and then it is installed. We have not gone through what are the terms and conditions of the app or about the data communication. What we want is just the app to be installed. Now, if I do the same philosophy in terms of signing a contract, and then one fine morning, I am being questioned that you are not performing according to the contract, then I might have to face a legal consequence. So what do I mean to say in short is that the person who is signing the contract must have understood each and every word that is written there. He should be in a position to execute the contract as prescribed and as signed on the document. Suppose he goes back, he says that, sir, I will not be able to perform as that has been written there, then that contract itself becomes a problem. So that's why we say that once you have entered the contract, please think about it before even entering the contract. Read the document 3 times, 5 times, 10 times and understand whether you have the capacity to execute the contract. Do not be in a hurry in signing the contract and then come back and say, sir, I did not know about it. That would not be accepted as per the court of law. So we always want the person to understand the consequences of entering into an agreement and then signing about it. Followed by, it is important to note that a contractual capacity and capacity have nothing to do with person's skill in bargaining or on the negotiation of a contract. The competency and the capacity have nothing to do with the person's skill in bargaining or negotiation. Now, that is not what we are looking into. Now, you have the capacity to bargain and get things. That is not what we are looking into. What we are looking in terms of a contractual capacity is that this person has the capacity to perform the contract. What is the person's skill? What talent he has? What is his nature of doing a job? We do not want to know. What we want to know is that as per the contract that is signed, does he have the capacity to perform? We are not introspecting into the person's intellectual behavior or other kind of forms of activities. We only want to know whether this guy can perform as said. Followed by, just a person does not understand everything in detail, and the provision in contract doesn't mean that they lack competence or the capacity to form the contract. Now let me take you to the other half also. It says very clearly, just because a person does not understand everything in detail and the provision in contract does not mean that they lack the competence or capacity. Now, there are many a times what happens here is that we ourselves do not understand everything that is being written on a legal document or on a paper. So what we tend to do is that we tend to assume things, or we tend to go and ask people, what is it, how is it, why is it? So by going by this general meaning or by the format that a person does not understand everything in detail doesn't mean that he does not have the capacity. It only means that he needs further enlightenment about it. which he can gain from his friends, from other knowledge sources altogether. But what is important here is that the capacity, we are only worried about the contractual capacity, whether he is clear enough, whether he is in position to sign or not to sign. That's all. We are not going into the intellectual introspection. That is not needed at all. How good you are, how well are you educated, do you know English, do you know X, do you know Y? We do not want to know that. We only want to know that the performance, whether you will be able to comply to the rules that are mentioned and take forward the contract. The next thing is, in short, it is enough that if a person understands that they are entering into a contract and understand the general nature of the contract. This is very, very important. Why I say this is that, now, for example, when you are going to give out your flat or house for rent, you sign a rental agreement with your tenant. Now, for your tenant as well as for you, it is not mandatory that you know the complete encyclopedia of civil engineering. No, that is not needed. All you need to know is that under what terms and conditions you are renting out, and for your tenant, he needs to understand how much he has to pay to you as rent every month. So that's all we want to understand. So in general, what we want to say is that the persons who are getting into the contract must understand the nature of the contract, must understand the terms and conditions of the contract, and they should not further divulge other kind of activities. The next thing is that most people who enter into a phone plan contract have no ability to negotiate and surely do not understand every detail. As I was trying to tell you about a software or about an app, this is exactly the same kind of thing. Many a times when we see that there are plans that are available, a 299 plan, a 199 plan, or a 599 plan, but we are not in a position to negotiate that. We are not in a situation where we can go ahead and say that this is what we exactly want. What we do is that we just follow the plans. What we tend to understand is that this plan can be followed, yes or no. If the plan can be followed, if the plan can be taken into account altogether, that means we have completed the task. So what we believe in contract is that we just want to understand whether you are in a position to sign the contract and take it forward. Now, moving further, let's try to understand, when does a person lack that contractual capacity? When does it happen? Why I don't have that capacity? In general, person who enters the contract presumably possesses the complete legal capacity to be held liable for duties if they agree to undertake, unless that person is a minor, mentally incapacitated or intoxicated. So we are going to talk about three conditions here. The first one being a minor below 18 years of age. The second kind of people, mentally unsound or unstable. Next, we are going to talk about the intoxicated personalities. Now, the first thing is that minor. A minor is defined in most states as a person under the age of 18. The law presumes that minors are too immature, inexperienced, and lack the legal capacity. Now, why a minor cannot come into contract? Very simple. The law says that people who are below the age of 18 do not have the legal capacity to take their own decisions and be a part of the contract. So they don't have the experience, they don't have the idea, they don't understand what is going on from a legal perspective, so they are banned from signing a contract. They are not being allowed, they are not being given the rights to sign a contract and form a part of a legal enforcement. So that is why a minor is not considered to have that factor called as contractual capacity. The next one, the court says that any contract made by a minor to be voidable at the minor's discretion in order to protect them from being held accountable into unwise contracts. Now, it is quite common that youngsters will not listen to us. They hate taking advice from elders. So they always have the fear factor, they always have the thought in their mind, why am I being banned? Why am I being stopped? So they go further and they say that no, I also have the rights, I will sign the contract, I know what I am doing. In that case, the court says that the minor has the right to be on the voidable contract. That means at any point of time, the minor's discretion, the minor can say, I don't want to pursue this contract anymore. Why? Because I don't want to get into trouble. This is where the court brings in a protection to the minor, saying that please do not start getting into the unknown waters. Please do not start getting into any kind of trouble without knowing the legality behind it. So that is why the court says that the minor has a discretionary power of avoiding the contract, saying that I do not know, or I have not understood, I am not in a contractual capacity to take that particular contract or offer it to the next level. Now, in other words, you can enter into an enforceable contract with a minor. They may dissolve the contract at any time with a few or limited exceptions. Exceptions to the minor being able to void contract will include the following. But before we start seeing what it is, let's first try to understand this. Can a minor actually get into a contract? Although you can enter into an enforceable contract where again you have a guardian, the guardian takes it on the factor saying that I shall on behalf of the minor take the contract, and he can take it further. But at that point of time also, the beneficiary as per the court is given to the minor, saying that he might go ahead and disavow the entire contract. He might say that I don't want this contract at all, I do not know about it, because he can take a protection for himself. But then let's see that where a minor is being able to void a contract. Now moving further, minor comes to an age. Now in most states, if a minor comes to age and now you are considered an adult and they have not done anything to void the contract, then the contract can no longer be voided due to the previous incapacity. So once you come off the age, then it cannot be considered to be no longer a voided position. Now, contracts for necessities. Most states do not allow a minor to avoid a contract for necessities such as food, clothing, and lodging. Now, when it comes to necessities, for a minor, he does not have much of option. He has to follow what has been told, and that's a mandatory part of the entire thing. So what happens here is that when a minor comes to the age is what we are trying to talk about, is once he reaches 18 plus. That means he will not be able to void any contract saying that, sir, I was a minor last year. No, now you are considered to be an adult, which means now you cannot go back and repeat what you were doing last year. Now you will be considered to be eligible to enter into a contract, and any contracts cannot be voided in that nature. Similarly, when you are looking for necessities, which means food, shelter, and clothing, the basic necessity of human life, at that point of time, you cannot avoid any contracts. Once you have signed for it, yes, it is mandatory for you to follow. Followed by further, persons who are mentally unstable. Now, those people and the people who are under the influence of drugs and alcohol are generally deemed to have any contractual capacity. So for example, you have gone ahead and formed an agreement with a person who is intoxicated by drugs or by any kind of alcohol format, and the sign you have taken up the contract, then that contract is said to be a void, because the court says that they do not have the capacity to sign the contract. Similarly, for mentally unstable people. Now, similar contracts with minors and that have been entered into persons who are intoxicated or who are in voidable situations altogether. But then these kind of factors have to be understood. Why? Because they say that but only if the party knew or had a reason to know the degree of impairment. Now, what happens most of the time is that There are situations where the party understands, though he might be in an intoxicated position, or sometimes the other party knows under which conditions he is signing. All these kind of factors do take a position of doubt. But what does the court say very clearly is that if the person has been proved that he was under the state of influence of alcohol or drug or any unwanted substances, then that person will not have the capacity to sign. Similarly, if the person is proven to be unstable in mind because of whatever reasons medically, that means he is considered to be unfit to sign the contract. So you will not be able to take the contract forward. Followed by, courts rarely show sympathy to people who try to void their contractual duties on grounds that they were intoxicated. As a practical manner, only void contracts upon showing the evidence demonstrates the sober party of clearly taking the advantage. Now, this is something which is quite dramatic in nature, or something that does not happen in the normal course of life. Now, what happens here is that suppose you have signed a contract under the influence of alcohol, and then you start pleading innocence before the court of law. The court will ask you to prove with evidence stating that you were completely unaware, which is, an unlikely chance altogether. So what happens here, the court says very clearly that unless and until there is a solid proof that you were put under pressure or you were under some circumstances coming into a contract of intoxication, other kind of activities, then only the court will give you a chance where you can take the advantage of saying that this contract is void. Unless and until all the contracts which are being signed, you have to follow the rules and regulations. It is very much enforceable under the law. Followed by, when does a person again lack this factor? We are continuing with that. The above is true when people are mentally unsound. They have been given certain medication, prescription factors. So therefore, these people cannot be coming into contract. So that is one of the reasons. Let's say that a person is undergoing a severe treatment or a therapy in some of the hospitals. You go in between just to get your work done. You go and sign on the contract, saying that yes, I have taken the permission, I have signed on the contract with that person altogether. That will not be considered true. Why? Because that person is now undergoing a medical treatment. He is not mentally fit enough to understand the terms and conditions. So you will not be able to take a complete yes from that side. So unless and until he is being given a clearance from the medical side saying that yes, you have cleared, you are now in a position to get into the contract, until then you are not supposed to take up a contractual agreement. Followed by, likewise, contracts entered into with a mentally incapable are voidable at the person's discretion. However, a mentally incapacitated person's guardian or personal representative may ratify the contract as a legal representative for that person, and therefore they might be converting it into a legal agreement. Now, what is the one single option that is being provided to you is that if there is a guardian for that person, for that mentally unsound person, he might be able to ratify the agreement and say that I will enter into an agreement, an enforceable agreement based on his behalf. So that's where that will become a binding contract. So you need to have a guardian. You need to have somebody who will represent this mentally unsound person, and then they can form a binding contract. Now, courts will usually evaluate a person's competency to form a contract at the time of contract formation rather than earlier time frame. And this is very important. Why? Because when you are signing the contract, we need to know what is your state, what is your capacity and stand altogether. We don't want to know your history, what you were some years back. Some years back, that person was rich, he had the capacity, he was financially sound. That is not needed for the court. What does the court exactly require is that at that point, at that juncture, when you are signing the contract, are you sound enough financially, mentally, physically, morally? Are you understanding the terms and conditions of contracts? And then you can go ahead and sign on this. Now, the next thing is that, as noted above, if a contract has been entered into but it is later discovered that one of the party lacks the contractual capacity, then it will become usually a voidable contract. Now, after signing a contract, one fine morning, the court discovers that the other person did not have the capacity and they signed on it, then automatically the agreement goes voidable. You will not be able to take it forward at all. Now, the next thing is that the party is not automatically relieved from any contractual capacities, though they might have incurred what they have told. The court need to do an additional analysis to determine whether they still need to fulfill any duties. Moment it becomes avoidable doesn't mean that contract is immediately scrapped, it is thrown away. The court will take further investigation into analysis. They will start seeing under what conditions this contract became voidable. Is it something which is done intentionally or accidentally, or there are certain further legal complications that are being added to the situation? Is it something really that we need to think and bring in? If that has not been understood, if that has not been told clearly, then automatically the contract will start getting into a voidable situation. Followed by, a party to contract will not be relieved from their contractual duties until the court completely says, yes, you are clear. So you cannot assume that moment that things becomes avoidable, the agreement is done, I'm out of the agreement. No, court has to give you permission stating that this has been cleared, the contract does not hold good anymore, then you are relieved out of the contract. This means court will first consider all the evidence concerning the party's mental capacity, make a determination from the evidence before relieving the person from its duty. So the court has to make a complete analysis. That's why we talk the importance of medical certificate, the financial certificate, whatever situation under which you are going through, everything needs to be presented to the court in the utmost truth manner so that you are able to understand, and then the court decides whether the party is now in an incomplete stage, whether he is in an incompetent stage altogether in terms of doing the contract. With this, I come to the end of this particular session. I hope and believe that all the information that is shared through this particular session will be of a great help and resource to you. In the upcoming sessions, we shall be learning about the minors agreement, which is a very, very important topic in commercial law. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.